Hello everyone, welcome back to Legal Student Studies channel. So in previous video we have covered second part of this series, that is for the business regulation subjects, which is taught under 5th semester DU LL.B faculty of the University of Delhi. So this is the last video for your 5th semester business regulation. In this part we have covered all remaining syllabus of the business regulations. So start. Let's have a look over the syllabus. In the second part of the video we have covered third topic and fifth topic and sixth topic, and in this video we will cover topic 7 and topic 8. So let's start. Let's open it. So now come to the topic 8 and topic 7 and topic 8. I hope you all are doing well, guys, and you are preparing well. Yes, and if you have any query regarding anything, you may text me on Telegram or Instagram. The ID is Prudent Rahul. So, this topic number 7 and topic number 8 in this video will cover. So let's start. Topic 7 of your syllabus talks about Telecom Regulatory Authority of India, in short TRAI, Act 1997. So this act was enacted to provide for the establishment of Telecom Regulatory Authority of India and the Telecom Dispute Settlement and Appellate Tribunal TDSAT to regulate the telecommunication services, adjudicate disputes, dispose of the appeal, and to protect the interests of the service provider and the consumer of the telecom sector. Telecom Regulatory Authority of India, a statutory regulator of the telecommunication sector, was set up under Section 3 of the TRAI Act. The objective of this act is to regulate the telecommunication sector and to consolidate all laws, rules, and regulations of the telecom industries. The Act has established the TRAI, that is Telecom Regulatory Authority of India, for the regulating and supervising the telecom industry, and the Telecom Dispute Settlement Appellate Tribunal (TDSAT) to adjudicate dispute between the licensor and the licensee. The Constitution of the tribe, which is provided under Section 3, some provision we will cover to better understanding of the Act. Tribe. Tribe is incorporated as a body of corporates having perpetual succession and a common seal, and having the power to hold and dispose of the property entered into the contract and the capacity to sue or be sued. In the pursuance of Section 3 subsection 2 of the Act, TRAI consists the chairman, not more than 2 whole-time members and not more than 2 time members. All these members are appointed by the central government, and the term of the office is either 3 years or till then attain the 65 years, whichever is earlier. Power and the function of the trial, which is mentioned under chapter 3 of the Act. Section 11 of the Acts gives the function of the performed by the TRI. This section overrides the Indian Telegraph Act 1885. The Act was amended in 2000, and the Amendment Act 2000 gave the four broad category on the function of the TRI: recommendatory function, regulatory function, fixing tariff for the telecom services, and any other function prescribed by the central government under section 12 and 13. Let's come to the regulatory function and recommendatory function. The authority has to make the recommendation to licensor either suo motu or upon an application of request. The matter on which the recommendations are made are need for the introduction of a new service provider and its timing, terms and conditions of the issuance of the license to a service provider, revocation of the license due to non-compliance of the terms and condition recommendation by the TRI, technology advancement in providing services, type of the equipment used and their inspections, effective management of the available spectrum. Regulatory function ensure the compliance of the terms and the conditions mentioned in the license. Fix the terms and conditions of the interconnectivity of the service providers. Ensure the technical harmony and the effectiveness in the interconnectivity between the service providers. Maintain a register containing all the interconnection agreements. Ensure the compliance of the universal service obligation and fixing the tariff for the telecom services. Under Section 12 of the Act, the TRI has the power to call for documents for the purpose of the investigation and the inspection. The TRI is obligated to carry out all the functions which, keeping in the mind transparency of the exercise of this power. Section 13 empowers the authority to issue directions for the carrying out its function. The central government has the authority to prescribe such other functions as are necessary. Telecom Dispute Settlement and Appellate Tribunal (TDSAT). Chapter 4 established the Appellate Tribunal. TDSAT lays down the procedure of the Appellate Tribunal. Establishment of Appellate Tribunal. The central government shall by notification establish an Appellate Tribunal to be known as the Telecom Settlement Tribunal. For what purposes? So yeah, I mentioned here to adjudicate any dispute, to hear and dispute of the appeal against any directions, or decision or order of the authority under this act, to exercise the jurisdiction power and authority conferred on. So these are the three main purposes for the establishment of the TDSAT: to adjudicate any dispute between the licensor and licensee, between the two or more service providers, between the service providers and a group of the consumers. The appellate and to exercise the jurisdiction power and the authority conferred on the appellate tribunal under the Information Technology Act and the appellate tribunal under the Airport Economic Regulatory Authority of India Act 2008. Chapter 5 includes the provision relating to the finance, accounts and audit of the two institutions established under the Act. Section 16 talks about the procedure and power of the appellate tribunal. The appellate tribunal shall not be bound by the procedure laid down by the CPC 1908, but shall be guided by the principles of natural justice and subject to the other provision of this Act. The appellate tribunal shall have the power to regulate its own procedure. Under subsection 2, that the appellate tribunal shall have, for the purpose of discharging its function under this Act, The same power as are vested in the Code of Civil Procedure 1908 while trying a suit under in respect of the following matter, namely, summoning and enforcing the attendance of any person and examining him on oath, requiring the discovery and production of the documents, receiving evidence on affidavits, subject to the provision of the section 123, 124 of Indian Evidence Act. Now it's became Bharatiya Saksh Adhiniyam 2023, requiring any public record or document or copy of such record or document from any office, issuing the commission for the examination of the witness or documents, reviewing its jurisdictions, decisions, dismissing and applications for the default or deciding it ex parte, setting aside any order of dismissal of any application for the default or any order passed by the it ex parte, any other matter which may be prescribed. Now come to the question asked in the 2022. Question number 6. ABC Company Telecom Company was granted a license by the licensor on a certain terms and conditions to provide the telecom service in India. Telecom Regulatory Authority of India under the TRI Act 1997 issued certain regulations which varied the terms and conditions of the license. The ABC Telecom Company refused to adopt and variations in the terms and conditions. TRI thereafter ordered to revoke the license of the telecom company for the non-compliance of the terms and the conditions. ABC Telecom Company challenged the order and of the TRI on the ground of the want of the jurisdiction and the regulations is ultra vires. The parent act, being the counsel of the company, argued the case with the help of the decided case law. Now come to the case law. The first case is Cellular Operators Association of India and others versus TRI. This was decided on 11th May 2016 by the Supreme Court. What was the facts? The TRI in the year 2015 was amended by the Telecom Consumer Protection 9th Amendment Regulation 2015. As per the amendment, every service provider of the cellular mobile telephone services has to credit 1 rupee for each call drop up to the 3 call drop a day to calling the consumer which happens within its network. The money should be credited to the consumer account within the 4 hours for the prepaid and for the prepaid customer and adjusted in the monthly bill of the postpaid customer. Agreed by the amendment reached the Delhi High Court, where it was held that the amendment regulation is valid regulation. Further, the Cellular Operators Association of India and others approached the Honorable Supreme Court, challenging the said judgment of the Delhi High Court. Issue whether the Ninth Amendment of the Telecom Consumer Protection Regulation 2015 is ultra vires to Section 36 read with Section 11 of the TRI Act, whether the impugned regulations violate the appellant's fundamental rights under the Article 14, 19(1)(g) of the Constitution. Dealing with the first issue, the Honorable Supreme Court held that the particular amendment is ultra vires to the Article Section 36 read with Section 11 of the TRI Act. Supreme Court said that the major power of the TRI Act is to regulate and making the power which is provided under the TRI Act, and this power should be used consistently as per the Act and the rules. It was said that the regulation was not meant to ensure the compliance of the terms and conditions of the license, nor has to be made to lay down any standards of quality of the services that needs to compliance. Hence, it is outside the purview of the Section 11. It was also held that as this amendment does not carry out the purpose of the Act under the Section 11. So it is also not valid under Section 36 of the Act. Hence, it is ultra vires. The amendment violates the Article 14 and 19(1)(g) as it was found by the TRI that the 36.9% of the cold drops takes place because of the fault at the consumer end, and hence the court observed that this being the case, it is clear that the service provider is made to pay for the cold drops that may not be attributable to his fault, and the consumer receives the compensation for a cold drop that may be attributable to the fault of the consumer himself, and therefore the imposing the strict liability on the service provider is erroneous, as in case of the cold drops, the service providers are not fully liable, and so it is arbitrary and unreasonable. Next case is BSNL versus Telecom Regulatory Authority of India. It was the civil appeal decided on 6th December 2013. The BSNL approached the Supreme Court for the relief against the decision of the TD Act, where the tribunal had ruled on the certain regulation and the order framed by the trial. In its decision, the TDSAT had relied upon its power contained in Section 14(b) of the TRI Act, under the which the TRI could here dispose of the appeal and against any direction, decision, or order of the authority under the Act. Decision in the exercise of the power vested in under Section 14(b) of the TRI Act, it is said does not have jurisdiction to entertain the challenge to regulate the frame by the TRI under the Section 36 of the TRI Act. The court held that the TDSAT did not have the power to examine the validity of the regulations made under the Section 36 of the TRI Act, and and concluded that the High Courts as well as the TDSAT had committed an error of the law in this regard. Now come to the topic number 8 and the last topic for your syllabus. Topic 8 talks about the Real Estate Regulation and Development Act 2016, in short RERA. An act to establish the Real Estate Regulatory Authority for the regulations and the promotion of the real estate sector in an efficient and transparent manner, and to protect the interest of the consumers in the real estate sector, and to establish an adjudicating mechanism of the speedy dispute redressal, and also to establish the appellate tribunal to hear appeals from the decisions, directions, or orders of the real estate regulatory authority and the adjudicating officer for the matter connected thereto and incidental thereto. The registration of the real estate project and the registration of the real estate agent under Section 3. Section 3, prior registration of the real estate project with the Real Estate Regulatory Authority. So no promoter shall advertise, market, book, sell, or offer for sale, or invite person to purchase in any manner any plot, apartment, or building, as the case may be, in any real estate project or part of it in the any planning area without the registering the real estate project with the Real Estate Regulatory Authority established under this act. The Section 4, the application for the registration of the real estate. Section 5 talks about the grant of the registration. Section 9 talks about the registration of the real estate agents. Now come to the Section 20, which talks about the Real Estate Regulatory Authority. The establishment and the incorporation of the Real Estate Regulatory Authority, the appropriate government shall establish an authority to be known as the Real Estate regulatory authority to exercise the power conferred on it to perform the function assigned to it under this Act. Section 59 talks about the offense, penalty, and adjudication. Section 59 punishment for the non-registration under Section 3 of the Act. If any promoter contravenes the provision of Section 3, he or she shall be liable to be penalty which may extend up to 10% of the estimated cost of the real estate project as determined by the authority. Subsection 2. If any promoter does not comply with the order, decision, and orders, direction issued under the subsection 1 or continues to violate their provision of the Act, section 3, he shall be punishable with imprisonment of a term which may extend up to 3 years, or with fine which may extend up to a further 10% of the estimated cost of the real estate project, or with the both. Now come to the case laws. Nilkama Realtors Suburban Private Limited versus Union of India. So on 6th December 2017 it was decided by the Bombay High Court Supreme. So, in virtue of the for the home of buyers, the Honorable Bombay High Court, by its judgment dated 6/12/2017, upheld the validity of the various provisions of the RERA Act. In the matter of the Nilkamal case, a bunch of the petition filed by the real estate developers and the individual plot owners and all challenging the constitutional validity of the RERA Act. The Honorable Bombay High Court upheld the RERA Act and its applicability to the ongoing project across the states. The petitioners challenged the constitutional validity of the various provisions, including first proviso to the Section 3(1), Section 3(2), Section 5, Subsection 3, Section 6, Section 7, 8, 18, 22, 38, 40, 59 पेनाल्टी का बात करता है and etc. of the RERA Act as being violating of the Article 20, 19(1)(g), 20 and the 300 capital A of the Constitution of India. The issue was whether the provision of RERA Act as amended as stated above are violating of the Article 20, 20, 19(1) and the 2300A of the Constitution or not. Whether the provision of the RERA Act has the retrospective or retroactive application decision. Supreme Court held that the provision to be the constitutionally valid and the legal after their harmonious construction. The judgment was given by the bench of the Honorable Justice Naresh H. Patil and the Arjit Ketkar and become a landmark judgment upholding the constitutionality of the RERA. The judges also said that this act is not an anti-promoter, but rather a pro-promoter act which gave them the authenticate and the professional platform. In this case, we can see that both the issues weren't sustainable, mainly because the acts inviting the operation of the act is a registration and not the contract between the promoter and the allottees. The power of the parliament to enact the retrospective acts and the larger public interest. Now the another case is Imperia Structural Limited versus Anil Patni 2020 Supreme Court का केस है. This was an appeal in this civil appellate jurisdiction of the Supreme Court. The center focus was whether the National Consumer Dispute Redressal Commission had any jurisdiction to rule in this case, as the project herein was registered under the RERA Act. Now, the Miss Imperia Structural Limited had launched a housing scheme named the Espera. Many allottees booked their apartment with the appellant by the paying the booking fee and entered into the buying builder buyer agreement. The respondent books until Anil Patni. Respondent booked the apartment number 1803. The basic price was 56,175, to which the additional charges were added, the aggregate price being 76 lakhs 43,000. The respondent had tuned to the national NCDRC for the compensation as the company had failed to deliver the possession as per the builder buyer agreement. The commission allowed the case along with the other similar cases and ruled against the appellants. So the issue was whether the complainants were consumers within the meaning of the acts. So if the consumer, then the NCRDC has jurisdiction over the measure. It was held the RERA Act and the Consumer Protection Act are two different legislation, and that despite the ongoing cases at RERA, the Consumer Forum will always have the power to entertain the cases wherein the home buyers qualify as consumers within the definition of Section 2D mentioned under the Consumer Protection Act 1986. So guys, thank you so much for watching this video. I hope by after watching the three parts of the series of this business regulation subjects, you you all will be able to understand the aspect of this course and also able to score good marks. So thank you so much for watching this video. If this video will help you by little bit at least, then please subscribe this channel and press the bell icon. And guys, you can also share to your colleague. So thank you so much again for watching this video. Thank you so much. If you have any query regarding anything, you may contact me on my Instagram channel or Telegram channel. My Telegram channel is same as YouTube channel, Legal Prudent Study, and you may contact on Instagram. My Instagram ID is Prudent Rahul, and the same ID also eligible for contact for Telegram. So thank you so much again. Thank you so much, guys.